They said I was not her son. The DNA report landed on the probate court clerk's desk at exactly 9:47 in the morning, and I remember that detail because I had been staring at the clock above the door for the previous 20 minutes, watching the second hand move in that slow, deliberate way clocks move when you are waiting for something you cannot stop. The courtroom smelled the way old government buildings always smell, like carpet that has absorbed too many winters and fluorescent light that has been burning since before anyone in the room was born. Outside on 5th Street in downtown Columbus, Ohio, it was a gray November morning, the kind where the sky sits low and heavy and the trees have already given up every last leaf. But inside that room, something was about to happen that would rearrange everything I thought I knew about my own life. My name is Daniel Mercer. I am 51 years old. For 49 of those years, I believed I was the son of Eleanor Mercer, a woman who taught 3rd grade for 31 years at Riverside Elementary School, who made the best lemon pound cake in Franklin County, who kept every report card I ever brought home in a shoebox under her bed, and who died on a Tuesday afternoon in April after a stroke that moved through her brain like a quiet tide and took her before any of us could say goodbye properly. For 49 years I believed she was my mother in every way a person can belong to another person. Then my brothers walked into that courthouse with a manila envelope and tried to take everything. There were 3 of them seated on the other side of the courtroom. Marcus, the oldest, sat closest to their attorney, his jaw set in that particular way he had when he had already decided an argument was over. He was 56 and had the thick shoulders of a man who spent his 20s lifting things and his 40s managing people who lifted things. Next to him sat Gerald, 2 years younger than Marcus, who kept clicking a pen in his left hand and looking toward the door like he was calculating exits. And then there was Kevin, the youngest of the 3 of them, 39 years old, and the only one who had the decency to look slightly uncomfortable about what they were doing. Kevin kept his eyes on the table in front of him. He had not looked at me once since we filed into the room. The attorney representing my brothers was a man named Preston Hartwell. He wore a charcoal suit and carried his briefcase the way certain lawyers carry briefcases. Like the weight of it communicates authority, he placed the manila envelope on the table in front of the judge, with the careful choreography of someone who had rehearsed this moment. "Your Honor," he said, the tone measured and confident, "my clients have requested this hearing to formally contest the estate of Eleanor Ruth Mercer on grounds that Mr. Daniel Mercer is not a biological son of the deceased, and therefore holds no legal standing as a primary heir." The judge, a woman named Constance Bird who had the calm, unhurried manner of someone who had seen every variety of human behavior a courtroom could produce, looked down at the papers in front of her. She did not look surprised. Probate court never surprises judges who have been sitting in it long enough. I sat at the table across the aisle from my brothers with my attorney, a woman named Patricia Chen who had practiced estate and family law in Columbus for 22 years. Patricia had short silver hair and a habit of keeping one hand flat on the table in front of her, like she was steadying herself against whatever came next. She had told me 3 days earlier when we reviewed everything we knew, that this hearing was going to feel like a fight. She also told me that some fights look different from the inside than they do from the outside. She was right about both things. Mr. Hartwell opened the envelope and produced a document that he presented to the court. "This," he said, "is the result of genetic testing arranged privately by my clients following the death of Mrs. Eleanor Mercer. The test compares DNA samples from the 3 surviving biological sons of Eleanor Mercer against a sample attributed to Mr. Daniel Mercer. The results confirm that Daniel Mercer shares no biological relationship with Eleanor Mercer." The word biological moved through that room the way a stone moves through still water. You could feel it ripple. I kept my hands folded on the table in front of me. I had been practicing that. Keeping still when everything inside you wants to move is something you have to learn deliberately. And I had been learning it since the morning my brothers showed up at my mother's house 6 days after her funeral carrying boxes and a locksmith. My mother had lived in the same house on Callaway Drive for 34 years. It was a pale yellow house with a front porch where she kept a metal glider that had been there since I was 8 years old, and a backyard where she grew tomatoes every summer with a stubbornness that impressed the neighbors because the soil on Callaway Drive was not particularly cooperative. After she died, that house was the centerpiece of her estate. There was also a savings account with $140,000, a small investment portfolio her financial advisor had managed for the last decade, and a life insurance policy naming all four of us as equal beneficiaries. Equal. That was the word in her will. Equal shares, equal standing, equal sons. My brothers had decided that equal did not apply to me. The morning they showed up with the locksmith, Marcus had stood on the front porch with his arms crossed and told me that they had spoken to an attorney and believed that the will could be contested on grounds that I was not Eleanor's biological son. He said it the same way he used to tell me I had struck out during our backyard baseball games when we were kids. Flat, certain, with no particular cruelty but no particular warmth either. Just a fact being delivered. I had stood on that porch for a long moment looking at the three of them, then at the locksmith who was staring at his shoes because he clearly wanted nothing to do with any of this. And then I said one thing. I said, Mom knew exactly who she was leaving this house to. And I went back inside. That was 6 weeks before the court hearing. In those 6 weeks I had done 3 things. I had hired Patricia Chen. I had visited my mother's oldest friend, a woman named Ruth Okafor, who had known Eleanor Mercer since they were both young mothers pushing strollers through Schiller Park in 1977. And I had spent a great many quiet evenings sitting at my kitchen table in the house I owned on the east side of Columbus, thinking about what it means to belong to someone. Judge Bird looked up from the document. Mr. Hartwell, she said, this DNA report was arranged privately by your clients. It has not been independently verified by this court. We understand that, Your Honor, Hartwell replied smoothly. We are prepared to request court-ordered verification. The judge nodded once, then looked toward our side of the aisle. Miss Chen, Patricia stood slowly. She had the unhurried quality of someone who had learned that rushing rarely improves anything. Your Honor, she said, before we address the validity of the DNA evidence, I would like the court to understand the full context in which this challenge is being raised. She paused just briefly. My client has lived as Eleanor Mercer's son for 49 years. He was raised in her home, educated with her support, and named as an equal heir in a will that Eleanor Mercer signed, witnessed, and had notarized 3 years before her death. The question before this court is not simply biological. It is legal, historical, and moral. Hartwell shifted slightly in his chair. The biology is the legal foundation, Your Honor. If no biological relationship exists, the will can be contested under Ohio inheritance statutes. Patricia kept her voice even. The biology, she said, is exactly what we intend to address. But not in the way opposing counsel expects. That last sentence did something to the air in the room. I felt it. Even Hartwell felt it because his pen stopped moving for just a moment. I looked across the aisle at my brothers. Marcus was still watching Hartwell. Gerald had finally stopped clicking the pen, and Kevin for the first time that morning looked directly at me. I held his gaze for a moment. Kevin had been the brother closest to me growing up. We had shared a bedroom until he was 12. He used to sneak into my room during thunderstorms when he was small because he was afraid of lightning, and I used to pretend to be asleep so he would not feel embarrassed about it. That was 30 years ago, and looking at him now across a courtroom where his name was on a legal filing designed to strip me of my family, I found myself wondering at what exact moment a person decides that money is worth more than everything else. I did not have a clean answer to that question. But I was about to learn a great deal more about what drives people to the places they reach. Let me take you back, because to understand what happened in that courtroom, you have to understand what happened long before it. In the years when Eleanor Mercer was simply Mom and the house on Callaway Drive was just home. I was adopted at the age of 2. I know that now, though I did not know it for most of my life. Eleanor and my father, Robert Mercer, who died of a heart attack when I was 17, had 3 biological sons before a series of medical complications made another pregnancy impossible. They had always wanted a larger family. My mother in particular had spoken about this openly in her later years, though she always framed it as a fact about the past rather than a wound. She said they had discussed adoption for 2 years before they finally made the decision, and that when she held me for the first time at St. Anthony's Children's Home on a cold February morning in 1975, she said she understood immediately that biology was simply the opening paragraph of a much longer story. I did not know any of this growing up. My parents made a deliberate choice not to tell me, not out of shame but out of a philosophy. My mother held firmly, which was that children should be allowed to simply be children before they are asked to process complicated truths. She had planned to tell me when I turned 18. Then my father died when I was 17, and the grief of that year swallowed everything. And she kept waiting for the right moment. The right moment never quite arrived the way she planned it, so she put it in a letter instead. The letter was sitting in a sealed envelope inside her fireproof document box when she died. Her will included a specific instruction to give that envelope to me upon her death. Marcus opened the document box before I arrived at the house the day after the funeral. I did not know that at the time. I did not know any of it until Ruth Okafor called me on a Sunday afternoon, 3 weeks after the funeral, and told me she needed to tell me something that my mother had shared with her in confidence years ago. Ruth was 74 years old, and spoke with the careful precision of someone who weighs every word before releasing it. She had been my mother's closest friend for nearly 50 years. They had met at a neighborhood watch meeting in 1977, and had talked on the phone almost every single day since then, right up until the week before my mother's stroke. When Ruth called me that Sunday, I could hear the steadiness in her voice that people have when they have made a decision they know is right, but also know will be difficult. "Daniel," she said, "I need to tell you something Eleanor told me in confidence. I have been sitting with this for 3 weeks trying to decide what to do." She paused. "But I think keeping it quiet would be a disservice to your mother's memory and a disservice to you." I sat down at my kitchen table. "Okay," I said, "tell me." Ruth told me that my mother had shared the full story of my adoption with her many years ago, and that in the last 2 years of her life, Eleanor had become concerned about exactly the kind of situation that was now unfolding. She had seen something shift in Marcus when the family began discussing the estate. A hardening. A calculation. She had told Ruth that she was worried Marcus might try to contest her wishes after she was gone, and that she had taken certain steps to make sure her wishes would be honored. "What kind of steps?" I asked. Ruth paused again. She told me that she had spoken to her attorney, and she told me one other thing. She said there was a letter in her document box addressed to you. She specifically told me it should go to you first. I sat very still in my kitchen. "The letter," I said quietly. "Yes," Ruth said. "Did you receive it?" "No," I said. "I did not." The silence between us lasted several seconds. When Ruth spoke again, her voice was careful. "Daniel," she said, "I think you need to look into what happened to that box." I called Patricia Chen the next morning. What followed was 3 weeks of quiet, methodical investigation. Patricia sent a formal request through the probate process for an inventory of all items removed from the estate property following Eleanor's death. Marcus, as the self-appointed executor in the weeks before the will was formally submitted to probate, had removed a number of personal items from the house. The document box was listed among them. Patricia filed a motion to compel the return of all items removed from the estate property prior to formal probate. The motion also included a request for disclosure of the contents of any sealed correspondence found within the estate. Hartwell objected. He called it procedural harassment. Patricia called it standard estate protection. Judge Bird sided with Patricia and ordered full disclosure. That was when things became interesting, because among the items Marcus had removed from the house was the document box. And inside the document box, my mother's sealed letter to me was gone. Marcus claimed it had never been there. Gerald supported that claim. Kevin said nothing, which was its own kind of answer. But there was something else in the box that Marcus had apparently not thought to remove, or perhaps had not understood the significance of. It was a second envelope, smaller, tucked beneath a folder of insurance documents. Inside that envelope was a handwritten note from my mother to her attorney, dated 14 months before her death, referencing a conversation they had about her estate plan. It mentioned, in my mother's precise third-grade teacher handwriting, that she had made arrangements to ensure that all 4 of her sons, and she underlined the word all, would be treated equally under her estate regardless of circumstances that might arise after her death. Regardless of circumstances. My mother had anticipated exactly what was happening. Patricia looked at that note for a long time when I brought it to her office. Then she looked at me. "Your mother," she said simply, "was a very careful woman." "She was," I said. "She just didn't always let you see how careful she was being." We kept investigating. Patricia contacted my mother's estate attorney, a man named Howard Graves who had his office in a small building near the Ohio State campus and who had been handling Eleanor Mercer's legal affairs for 19 years. Howard Graves was 70 years old and had the particular demeanor of attorneys who have worked with families long enough to see every way families can fall apart. When Patricia explained the situation, he was quiet for a moment. Then he said that he could not discuss client communications, but that he strongly encouraged us to file the appropriate motions and allow the court to request his records. Patricia filed those motions within 48 hours. We also did something else. We requested a copy of the original DNA test that Marcus had submitted to the court. Patricia hired an independent laboratory in Cincinnati to review the methodology. The independent lab's assessment came back in 11 days. Their findings sat inside a folder that I now had with me in the courtroom, resting on the table beside Patricia's legal pad. I had not opened that folder in the car on the way to court. I had not needed to. I already knew what was inside it. What I want to explain before I go back to what happened in that courtroom is what it felt like during those 6 weeks to have your entire understanding of yourself put into question. Because that part is real regardless of what documents say, or what labs confirm, or what judges decide. When 3 people who grew up in the same house as you stand up and tell the world that you do not belong to the woman you have called mother your entire life, something happens inside you that legal proceedings cannot fully address. I will tell you what it felt like. It felt at first like a kind of weightlessness. Not the good kind. The kind where the floor drops away and you realize nothing is as solid as you believed it to be. I sat in my house on quiet evenings during those 6 weeks and found myself looking at photographs differently. There is a photograph on my living room wall of me and my mother at my college graduation. I am 22 years old and grinning the way young people grin when they do not yet know how complicated everything is going to get. My mother is standing beside me in a blue dress, and she is looking at the camera, but her expression is not quite a smile. It is something quieter than a smile. It is the expression of someone who is deeply, specifically proud. I had looked at that photograph 100 times over the years without analyzing it. During those 6 weeks, I stood in front of it for a long time one evening trying to see something different in it, trying to see a woman who had been pretending. I could not see it because it was not there. Whatever the birth record said, whatever the DNA showed, my mother was not pretending in that photograph. She was not performing something. She was simply there, being my mother, in the only way she had ever been anything, which was completely. That understanding did not make the legal fight easier, but it made it cleaner. It made me know what I was fighting for, which was not money and not a house and not a number in a bank account. I was fighting for the truth about who my mother was and what she had chosen, and why her choice deserved to be honored. I was also fighting because someone had stolen a letter she wrote to me, and I was not going to let that stand. Back in the courtroom, Judge Bird had asked Patricia to explain her statement that the biology would be addressed in a way opposing counsel did not expect. Patricia stood with the easy confidence of someone who has done this long enough to know that the moment before evidence is presented is often more powerful than the evidence itself. "Your Honor," she said, "my client does not dispute that he was adopted as a child by Eleanor and Robert Mercer." She let that sit for exactly 1 second. What my client disputes is the claim that the DNA report submitted by opposing counsel accurately represents what it claims to represent. Hartwell looked up quickly. The report was prepared by an accredited laboratory. Patricia nodded agreeably. It was, and that is precisely why we requested an independent review. She reached toward the folder on the table and produced the independent lab's assessment. "With the court's permission," she said, placing it before the judge, "I would like to submit the findings of an independent forensic genetics laboratory, retained by my client, which reviewed the methodology and chain of custody documentation of the original tests submitted by opposing counsel." Judge Bird received the document and began reading. The room was very quiet outside. A truck moved along 5th Street, and for a moment its engine sound filled the silence. I watched my brothers across the aisle. Marcus had gone still in a way that was different from his earlier stillness. His earlier stillness had been the stillness of confidence. This was something else. This was the stillness of a man who has just realized he may have miscalculated. Gerald had put the pen down entirely. Kevin was looking at his hands. Judge Bird read for nearly 2 full minutes. That is a long time in a quiet courtroom. When she finally looked up, her expression had not changed in any dramatic way. But there was something in her eyes that had shifted. It was the expression of a judge who has just found something worth paying attention to. "Miss Chen," she said carefully. "The independent laboratory is raising questions about chain of custody." "Yes, Your Honor," Patricia said. "Specifically, the independent lab's review found that the DNA sample attributed to my client, the sample used to determine that he shares no biological relationship with Eleanor Mercer, cannot be verified as having been obtained from Daniel Mercer. There is no documented proof of when or how that sample was collected, by whom it was handled, or whether proper protocols were followed to prevent contamination or substitution." Hartwell was on his feet. "Your Honor, the laboratory we used is fully accredited, and their procedures are standard." Patricia kept her voice pleasant. "The laboratory's procedures may well be standard. The issue is not the laboratory's procedures. The issue is what was given to the laboratory and by whom." The judge looked at Hartwell. "Mr. Hartwell," she said, "can you provide documentation of how the DNA sample attributed to Mr. Daniel Mercer was obtained?" Hartwell opened his briefcase and shuffled papers for a moment. He produced a document. He presented it to the judge. "The sample," he said, "was obtained with my client's cooperation." Patricia spoke evenly. "Your Honor, the documentation Mr. Hartwell has just presented shows that the sample attributed to Daniel Mercer was collected and submitted by Marcus Mercer. There is no documentation of Daniel Mercer's presence, his consent, or any witness verification that the sample came from him at all." The judge studied the paper in front of her. "We are not saying the laboratory made an error," Patricia continued. "We are saying that the sample submitted to the laboratory as belonging to Daniel Mercer may not have come from Daniel Mercer at all. And with that, the entire structure of my brother's case developed a crack that ran from the foundation straight to the top." I watched Marcus across the aisle. His jaw was still set, but something behind his eyes had changed. He leaned toward Hartwell and said something in a low voice. Hartwell responded with a slight shake of his head. Patricia was not finished. "Your Honor," she said, "we have additional evidence to present." She reached into her folder and produced 2 more documents. The first was a formal letter from Howard Graves, my mother's estate attorney, submitted pursuant to the court's earlier order requiring disclosure of communications relevant to the estate plan. Mr. Graves, Patricia explained, confirms in this letter that Eleanor Mercer met with him 14 months before her death, and specifically amended language in her estate plan to include a clause addressing the possibility that her son Daniel's adoption status might be raised as a challenge to his inheritance rights after her death. Judge Bird reached for the letter. Eleanor Mercer, Patricia continued, explicitly directed her attorney to include protective language in the estate documents because she had reason to believe such a challenge might be attempted. She was not surprised by what her sons might do. She planned for it. The second document Patricia produced was a certified statement from the Records Department of Franklin County Children's Services, confirming that Daniel Mercer had been legally adopted by Robert and Eleanor Mercer in 1975. And that under Ohio law, a legally adopted child holds the same inheritance rights as a biological child in all matters of intestate and testate succession. Patricia set both documents before the judge and then said something quietly and clearly that I will not forget for as long as I live. She said, "Eleanor Mercer was Daniel Mercer's mother. She chose him, she raised him, she planned for him, she protected him even after she was gone. The question before this court is not whether he shares her DNA under Ohio law. That question is irrelevant. The question is whether her clearly documented, legally sound, repeatedly affirmed wishes will be honored." The courtroom was silent. Judge Bird read both documents fully. When she finished, she placed them carefully on her desk and looked toward my brother's side of the room. "Mr. Hartwell," she said, "I have several concerns about the evidence your clients have presented. Concern 1 is the chain of custody issue with the DNA sample, which this court cannot overlook. Concern 2 is that even if the DNA results were verified as accurate, Ohio Revised Code is clear that legally adopted children retain full inheritance rights, equivalent to biological children. Concern 3, she said, and here her voice took on a particular quality, is that this court has now received documentation suggesting that the person managing this estate in the weeks following Mrs. Mercer's death may have removed items from the estate property, potentially including correspondence addressed to the primary heir. Before formal probate proceedings were initiated, Marcus shifted in his chair. That last concern, the judge said, falls outside the scope of this hearing. But I am noting it in the record, and I am referring it to the probate investigator's office for further review. Hartwell stood. Your Honor, we would like to request a continuance to address the chain of custody question. Patricia spoke calmly. Your Honor, my client has waited 6 weeks while his mother's estate has been held in limbo, following a challenge that rests on a DNA report of questionable validity and a legal theory that does not hold under Ohio statute. I would ask the court to rule on the estate matter today and allow any additional matters to proceed on a separate track. Judge Bird was quiet for a moment. She looked at the documents in front of her. She looked at me, then at my brothers. She looked at the report from my mother's attorney. She looked at the adoption certification. Then she said something that I had been waiting 6 weeks to hear, though I had not been entirely certain I would. This court finds no legal basis for the challenge to Daniel Mercer's status as an heir under the estate of Eleanor Ruth Mercer. The DNA evidence presented by opposing counsel is inadmissible due to chain of custody deficiencies. Furthermore, the court notes that under Ohio adoption law, Mr. Mercer's standing as an heir is not subject to challenge on biological grounds regardless. The estate shall proceed to distribution as specified in Mrs. Mercer's will, equal shares to all 4 sons. She brought the gavel down once. It was not a dramatic sound, just a clean, final click of wood on wood. I sat for a moment without moving. Across the aisle, Hartwell was already speaking quietly with Marcus, who had his elbows on the table and his head slightly bowed. Gerald was looking at the far wall. Kevin had put his face in his hands. Patricia placed her hand briefly on my forearm. That is it, she said quietly. It is done. I nodded. I could not quite locate the right words yet, so I didn't try. Instead, I just sat there in that courtroom on 5th Street and let the moment settle around me the way things settle after a storm passes. When the air is clean and still, and you can hear yourself think again. We stayed in the courtroom while Hartwell spoke to the clerk and Marcus and Gerald gathered their things. When Marcus finally stood and turned toward the door, he passed close to our table. He did not look at me directly, but he slowed for just a moment as he passed, and I could see his face in profile, and what I saw there was not the expression of a man who had lost a legal argument. It was more complicated than that. It was the expression of a man who had done something he could not undo, and who was beginning to understand that fully for the first time. I did not say anything to him. There was nothing I could have said in that moment that would have been right. Gerald followed Marcus out, then Kevin stopped. He stopped right beside our table and looked at me with an expression that contained more information than I knew how to process all at once. There was guilt in it, clearly, but there was also something that looked like relief, the particular relief of someone who did not want to be where they were and is glad the moment has passed. Daniel, he said. His voice was very quiet. I looked at him and waited. I am sorry, he said. He did not say anything else. Just those 2 words, but he said them like he meant them. Like they were the distillation of something much longer that he did not know how to deliver properly in a courthouse hallway with his older brothers waiting for him by the elevator. I said, I know. He nodded once and walked out. Patricia and I gathered our files and walked out into the marble-floored corridor of the courthouse, where the ordinary business of the building continued. People with folders hurrying past. A maintenance worker pushing a cart. A group of law students clustered near the stairs speaking in the urgent whispers of people who are practicing at taking things seriously. Life going on as it does, even when yours has just shifted on its axis. We took the elevator down and stepped out onto 5th Street into the gray November air. Patricia turned up the collar of her coat. That, she said, is why you document everything. I looked out toward the street. A bus moved past, its windows fogged from the inside with the warmth of the people in it. For a moment I just watched it go. There is something I want to explain about what I felt standing on that sidewalk. Because it was not what I expected to feel. I had expected relief, and there was some of that. I had expected vindication, and there was a little of that too. But what I felt most strongly, standing there on that gray November morning after winning the legal argument I had spent 6 weeks preparing for, was something closer to sadness. Not for myself, for my family, which is a strange thing to feel after a family has just tried to take something from you. But grief does not ask whether it is convenient, and standing there I was grieving things that the judge crueling could not restore. I was grieving the version of my 3 brothers who, as boys, used to share a house with me on Callaway Drive. Marcus, who taught me how to ride a bicycle in the parking lot of Riverside Elementary on a Saturday morning. Gerald, who once stayed up all night with me when I had pneumonia at 14, not because anyone asked him to, but because he was there. And that was what you did. Kevin, small and scared of thunder, slipping quietly into my room in the dark. Those people still existed, somewhere inside the men who had just walked out of that courtroom. I was grieving the distance between who they had been and what they had chosen, and I was grieving my mother because I had not been able to read her letter. Whatever she had wanted to say to me in that sealed envelope, whatever words she had chosen to explain the truth she had been carrying, and the love she had been giving my entire life, I had not heard them in her voice, or seen them in her handwriting. Someone had decided they did not want me to have those words, and those words were gone. Patricia walked me to my car when we reached it. She turned and looked at me with the direct, clear-eyed way she had. "How are you?" she asked, not as my attorney, just asking. "I thought about it honestly," I said. "I am okay. I am going to be okay. I just need a little time," she nodded. "That is a sensible answer," she said. She paused. "For what it is worth," she said, "your mother clearly knew exactly who her son was. Everything she did showed that." I thanked her. We shook hands, and she walked back toward the courthouse, and I stood beside my car for another minute in the November cold before I got in. What I did not do in the weeks and months that followed is something I want to tell you about, because I think it matters as much as anything else in this story. I did not call the newspaper. I did not hire a second attorney to pursue Marcus for the missing letter. I did not post anything on the internet. I did not contact my brothers demanding apologies or explanations or repayment of my legal fees. I did not tell the extended family the details of what had happened in that courtroom. Though word traveled on its own, as word always does in families, I am not saying that those would have been wrong choices. Other people in the same situation might have made them and been entirely justified. But they were not my choices, and I want to be honest about why. My mother spent her whole professional life teaching 8-year-olds. She used to say that the most important thing she tried to teach them was not reading or arithmetic, but rather how to decide what kind of person they wanted to be before the difficult moment arrived. So that when the difficult moment came, they already knew. "You do not figure out your character in a crisis," she used to say. "You discover what your character already is." I had spent 49 years watching her decide, again and again, to be a person of quiet dignity and measured grace. She did not make a show of her values. She simply lived them. When my father died, she did not collapse into resentment at the unfairness of it. She steadied herself and kept going. When the school where she taught cut her program's budget for 3 years running, she did not become bitter. She bought supplies with her own money and kept teaching. When Marcus and she had a falling out over a family disagreement several years before she died, she did not hold it publicly or punish him with silence. She kept calling him every Sunday. I was not going to dishonor that by turning her death into a war, so instead I did the following things. I had a conversation with Kevin. We met at a diner near Clintonville on a Saturday morning in December, 6 weeks after the court hearing. He was already there when I arrived, sitting in a booth near the back with a cup of coffee he had not touched. When I sat down across from him, he looked at me with the expression of someone who has been rehearsing a conversation for weeks and is not sure any of the rehearsed versions are going to work. I spoke first. I told him I did not want an elaborate apology. I told him I understood that family pressure is real and that the oldest sibling in a group of brothers carries a particular kind of gravity that is hard to push against. I told him that I knew he had been uncomfortable with what they were doing, because I had seen his face in that courtroom, and I had known him for 40 years. I told him the only thing I actually wanted from him was honesty going forward, which meant if he disagreed with something, he would say so directly rather than go along with something he knew was wrong. Kevin was quiet for a long moment. Then he said, "I should have said something sooner." I knew Marcus had the document box before you got there. I knew what he was looking for. I didn't he tell you? I know, I said. That makes me as responsible as he is, Kevin said. Maybe, I said. But you are here now, and he isn't he that counts for something. Kevin looked out the window at the December street, he said. Mom would be ashamed of us. I thought about that. Yes and no, I said. She would be sad. She wouldn't he be ashamed of you. She never was. He picked up his coffee finally and held it with both hands. How do you do that? He asked. Do what? Not be angrier, he said. I thought about how to answer that. After a while I said, I am angry. I was very angry for a while, but I kept thinking about what she would do with the anger, and she would find somewhere useful to put it. So that is what I am trying to do. We sat there for another hour. We talked about my mother. We talked about things we remembered from the house on Callaway Drive. Kevin told me that when he was 7, he had broken a window in the garage throwing a baseball and had never told anyone. And my mother had never brought it up either, which meant either she had never known or she had known and decided it was not worth making into something larger than it was. We agreed it was probably the second one. That was very much her style. I settled the estate with the help of the probate court over the following months. My equal share was distributed as the will specified. I sold my portion of the house back to my brothers at fair market value, because I did not want to force a sale of a house where Marcus' children had spent holidays. I kept certain personal items. My mother's metal glider from the front porch, which now sits on my own front porch. The shoebox of report cards she had kept under her bed, and the note she had written to her attorney 14 months before her death, in her precise third grade teacher handwriting, with the word all underlined. I had it framed. It is on the wall in my home office, near the graduation photograph. 2 pieces of evidence of the same truth. A woman who chose clearly and loved specifically and planned carefully for the people she had decided were hers. In the spring following all of this, I contacted St. Anthony's Children's Home, the place where Eleanor and Robert Mercer had adopted me in February of 1975. The facility had long since been reorganized under a different name and structure. But their records existed, and I was able to request access to my own adoption file. I sat in a small office with a caseworker named Maria who had gentle eyes and handed me the file with both hands the way people hand you something they understand is significant. Inside was a photograph I had never seen. It was a small black and white photograph, slightly faded, of my mother holding me. I am 2 years old in the photograph and I am looking at the camera with the vaguely suspicious expression small children sometimes have when cameras are pointed at them. My mother is looking at me. Her expression is the same one she is wearing in the graduation photograph on my wall. That same quiet, specific, complete thing that is not quite a smile. The expression of someone who is exactly where they decided to be. I sat in that small office for a long time with that photograph in my hands. Maria did not rush me. She brought me a cup of water and sat quietly at her desk doing other work and let me have the time I needed. Eventually, I thanked her and drove home. I put the photograph on my desk where I can see it when I sit down to work each morning. There is one more thing I want to tell you, which is about the letter. The letter my mother wrote me that disappeared from the document box. I never recovered it. The probate investigator's office conducted a review and was unable to conclusively establish what had happened to it, which is one of those outcomes that is deeply unsatisfying in a practical sense, but also, after a while, becomes something you have to make peace with. But Ruth Okafor, who had been my mother's closest friend for 50 years, and who had spoken with her almost every day until the week she died, called me one evening in February, a few months after everything was resolved. She said she had been thinking about the letter and about what my mother would have wanted me to know, and she asked if she could tell me what she remembered of what my mother had shared with her over the years about why she had made the choices she made. I sat down in my kitchen with the phone held close and listened. While Ruth talked for a long time, she told me that my mother had said many times that becoming my mother had not felt like taking on a responsibility or fulfilling an obligation. She said it had felt like finding something she had not known she was looking for. She said my mother had described the morning she held me for the first time with a specificity and warmth that had not diminished over the decades since. She said my mother had told her that when people asked how many children she had, she always said 4 without hesitation, because 4 was the answer that was true, and the truth had never felt complicated to her. She said my mother had wanted me to know, if she had not found the right moment to say it while she was alive, that she had never for a single day thought of me as anything other than her son. Not the adopted one, not the different one, not the complicated one, just her son. The word she used, Ruth said, was simply, she simply loved you, Ruth told me. The same way she simply loved the others. No more, no less, no asterisk. I sat at my kitchen table for a long time after that call ended. Outside it was a February evening in Columbus, Ohio, which is one of the colder and grayer varieties of February evening available in the Midwest. The street was quiet. Somewhere down the block, a neighbor's dog was barking at something only the dog could see. I thought about my mother sitting at her kitchen table on Callaway Drive for 34 years, grading papers in red pen late at night, making lemon pound cake on Saturdays, keeping report cards in a shoebox. I thought about the metal glider on the front porch and the tomatoes in the backyard. I thought about the letter she had written and lost, and the note she had written to her attorney with the word all underlined. I thought about a woman who had made a choice in a cold February morning in 1975, in a building that no longer exists, and had never once reconsidered it for the rest of her life. I am 51 years old. I have no children of my own, which means there is no one for me to pass this story to in the natural way parents pass things to children, through the small daily accumulations of shared life. So I am putting it here instead, in the open where anyone who needs it might find it. What I want to say is this: family is not simply the people who share your blood. That is one version of the word, and it is not wrong, but it is incomplete. Family is also the people who choose you before you can choose them. It is the person who sits beside you in a hospital cafeteria when you are 17 and your father has just died and tries to hold the world together for you, even when their own world is also falling apart. It is the woman who keeps your report cards in a shoebox under her bed for 49 years. Not because she is obligated to, but because they are evidence of your life, and your life is the thing she values most. The people who tell you that blood is all that matters are often the people who want something from you that your love is not enough to give them. I have learned this now. I have learned it at some cost. But I have learned it clearly. If you are someone who has been told that you do not belong to the family you believe is yours, I want you to hear this. Belonging is not a biological phenomenon. It is a choice that is made, sometimes daily, sometimes over a lifetime. Sometimes in a single cold February morning that a person never forgets. If someone chose you, you belong to them. No courtroom, no DNA report, no legal filing can undo a choice that was made with that kind of completeness. My mother knew who her son was. She always knew. She told everyone who mattered. She told her attorney. She told her oldest friend. She told the shoebox under her bed. She told me in every way she could manage except the letter, which was taken before I could read it. But the people who took that letter did not take what was in it. They could not. It was already inside me, having been delivered every single day for 49 years. I keep the photograph from St. Anthony's Children. It's home on my desk in it. I am 2 years old, and my mother is looking at me the way she always looked at me for the rest of her life, as if I was exactly where I was supposed to be. I think she was right about that. I think I was. And if this story has found you, wherever you are, I hope you know that the people who love you clearly and choose you without hesitation and plan for you even when they are gone, those people are yours, not because of biology, because of everything else, because of showing up. Because of showing up, because of staying, because of deciding quietly and completely that you are the person they love and never once reconsidering. That is the whole story, or most of it. The rest belongs to a metal glider on a front porch in Columbus, Ohio, and a shoebox, and a woman who underlined the word all because she needed whoever read it to understand that she meant every single person she had chosen, without exception, without asterisk, without end.